in the laws that we're talking about, unlawful ownership of a dangerous dog, I mean, it ranges everything from a dog threatening to attack, meaning it came up, it behaved in an aggressive manner, all the way through to severe bodily injury. I mean, so you've got, an entire gamut of damage that could have been done, and there was no injury involved. I mean, so you've got one law that addresses all of that. The process is the same for us as it is for any law enforcement. You go out, you determine, what has happened. In most dangerous animal cases, you've got an individual who's providing you with information, here's what happened. The officer who's addressing the situation determines, if there's probable cause to believe that there's a violation, that has been committed. If there is, then they issue a citation. Not necessarily proof. I mean, because the burden of proof to issue a citation is probable cause, and that's a lot different than, beyond a reasonable doubt. So that's why people get charged and, are not convicted, or the case is otherwise dispositioned, so you may have enough information to establish probable cause. However, there's not enough evidence to convict someone of a crime because there's, a different standard of proof, probable cause versus beyond a reasonable doubt. There isn't ever a black and white. No, absolutely not. I mean, so we may, conduct an investigation. We may issue a citation believing we have probable cause. And then when those charges go over to the DA's office, it's, fairly not common. It's not an everyday occurrence, but certainly there are a lot of cases where, we believe we have probable cause. We issue a citation and the DA's office may say, no, we don't believe, there's probable cause, and basically, does away with the charge. In the case of a dangerous animal, it could be the dog was running at large, it wasn't licensed, and it acted, inappropriately. So the DA, basically works a plea deal. Plead guilty to the dog at large will dismiss the license charge and will dismiss the dangerous animal charge. The majority of the time, they're dispositioned in some other way. The owner agrees to do some kind of behavior modification or, something of that nature, agrees to some kind of containment or is fined, and it goes away the majority of the time. But it's fairly common for these trials to happen, especially where there's a lot of disagreement. An owner saying, absolutely my dog did not do this, and a victim who is saying, this dog threatened my safety, and you've got a lot of passion on both sides of that. That's typically where you'll see it go to trial. I mean, it's an everyday occurrence. I mean, we issue, about one a day on average. I mean, obviously there's days that are much busier than other days, but, it's a fairly common occurrence. What we do, our primary concern, our job at the end of the day is pretty simple. I mean, first and foremost, protect public safety. We're always going to err on the side of caution. I mean, always.